All right. So this is a plea form, chat. This is a standardized form. Now, I don't know in Minnesota, is this something that's derived from the state level, or if this is derived just at the local court level? It could be either or. From here, this is a petition to enter a felony plea of guilty in a felony case pursuant to Rule 15. And that's Rule 15 of their Rules of Criminal Procedure. That's why you see that there. So here we go, chat. So this is the state of, it starts off all the basic stuff at the beginning. They are in the 8th Judicial District. This is the case number. If you guys want to look it up on the Minnesota Court Records, MCRO, this is the case number if you're looking for it. If you type it in like this with all the dashes, you will find the case. It was filed today, the 24th. State of Minnesota in Kandiyohi County. And it's the state of Minnesota versus Nicholas Robert Rekieta. And that's our boy. And it says, to the above named court, and it says, I, Nick Rekieta, the defendant in the above entitled action, do respectfully represent and state as follows. And I will just say respectfully. Remember that that's a relative term, so we'll just leave that alone. And he says, if followed on my case, I have received a copy of, in this case, not the indictment, but the complaint. He says, I understand the charges made against me in this case are possession of drugs in the second degree, possession of firearms or ammunition because of the possession of drugs, and then the child endangerment because of the possession of drugs. Now, guys, remember, the top one is the felony. These bottom two are misdemeanors. And these were committed on or about the 23rd of May, 2024 in Kandiyohi County. And he says, I am represented by an attorney whose name is Francis Herbert White III. Once again, I will say I don't think this guy did a very good job for Nick. I think it was actually pretty poor. Even if this was where Nick was telling him what to do or giving him things to do or really putting an input, you got to control your client. You have to tell them, listen, you don't know what the fuck you're doing. I know what I'm doing. Let me help you. Let me take care of things. So I think they failed in their client management and client control. But yeah, I was very disappointed in this. This was not an impressive showing. And I just think overall it was very poor. And from here, though, Nick is attesting and certifying that I feel I've had sufficient time to discuss my case with my attorney. I'm satisfied my attorney is fully informed as to the facts of this case. My attorney has discussed possible defenses to the crime I may have, and that I am satisfied that my attorney has represented my interests and fully advised me. And, he has advised Nick, but it then becomes the issue of, like, are you truly satisfied with their service? But Nick is saying yes. And he says, I've never been a patient in a mental hospital. And this, guys, here is just, oops, check the wrong box. That happens. I have not talked with or been treated by a psychiatrist or other person for a nervous or mental condition. Now, these two are important because here, if you have a mental defect or disease, or if you're having some sort of mental issues, the court will want to know, because this is a document you're signing and you need to be able to show you're clear-headed, you understand what's going on, you can comprehend it. If you're not competent, that becomes an issue. So why do they ask all of this? Because this prevents, once again, somebody like Nick from coming back later and saying, oh, I was in a mental hospital when I was 12, and oh, I was crazy, and you didn't know, and you didn't ask, and therefore this plea gets thrown out, and we should go back to the hearing because I didn't like how it went. That's what this is for. As I mentioned with Kurt, these things are all in here because something happened when somebody appealed, and the court's like, okay, yeah, I guess we have to fix this. So that's why these things are in here, to show that he's doing this of sound mind. He clearly understands the consequences of decisions, the weight of what he's doing, and how this works. And he says, from there, he says, I have not been ill recently. Now, when it says ill, that probably means of it, just normal, like you don't have the flu, you don't have a headache, yeah, I came in here and I woke up and I was feeling like I was going to die. So yeah, I agreed to stuff I didn't know I was signing. Once again, it's another one of those issues. He says, I have recently been taking pills or other medicines. Now, they ask you this because they need to make sure, do those medicines and medications affect your ability to enter into this plea? Do they cloud your judgment? Do they impair your judgment? Are there cognitive issues? And the way I try to explain it to people when I have clients with this, is it stuff that you wouldn't be able to operate a car or heavy machinery? Any medicine like that, clearly, you can't do that. Well, clearly, entering a plea would be bad because you're in the influence of something. But there are also psychotropic drugs. There's also psychiatric medicines that affect how you think and how you're processing things. So the court wants to know. And once again, this is about establishing the record that he did this of sound mind. It was knowing, voluntarily, and intelligently pled to. Because as long as you can show that, the court's not going to be inclined to overturn or will let him withdraw a plea when it gets to the appellate courts, because they're going to say, look, you already did it. We're not going to send it back. So that's why we see all this. And he says for number 10, I do not make the claim I was so drunk or so under the influence of drugs or medicine I didn't know what I was doing at the time of the crime. Well, let's be real. I think, he... I mean, are we going to say that he wasn't? I don't know. They didn't charge him with an OVI offense, so maybe at that second they didn't think so. He's saying, and not at the time of the crime, I was acting in self-defense or merely protecting myself or others at the time of the crime. Once again, guys, these two here are, so you can't claim, well, I had an affirmative defense and I'm protesting. All right. There were facts not in the way. This is establishing something for the record. He says, I do not make the claim that the fact that I've been held in jail since my arrest and could not post bail caused me to decide to plead guilty in order to get the thing over with rather than waiting my turn at trial. And that happens, guys. People sitting in jail, you don't get to see your family. It weighs on people. Kids saying, Daddy, when are you coming home? Or when the wife calls you crying, it's like, when is he getting out? And I'm like, he can't. We tried and we can't get a lower bond, or he's being held without bond. Those things happen. And people will enter pleas for that. The government does use that as a tool of coercion, and enforcement is getting people to plea in those situations. It does happen. He said, for number 13, I was represented by an attorney, and he did not have a probable cause hearing. He didn't have a probable cause hearing. I think he waived it initially at the beginning. And then he just did a contested omnibus, if I remember correctly from the arraignment. So all this here, he is kind of waiving this, but he says, I know that I can now move the complaint against me to be dismissed for lack of probable cause. And I know that if I don't make such a motion and go ahead with entering my plea of guilty, I waive all right to successfully object to the absence of a probable cause hearing. And he says, I also waive that all right to successfully object to any errors in the probable cause hearing when I enter my guilty plea. So Nick is giving up these rights, and he tried to challenge a probable cause, but once again, remember that bumbling, ham-fisted Frank's motion kind of ruined all of that. From there, he's then attesting, my attorney has told me, and I understand the prosecutor of this case against me has evidence obtained as a result of searching and seizing the evidence. Evidence in the form of statements, oral and written, that I made to police or others regarding this crime. Evidence discovered as a result of my statements or as a result of the evidence seized in a search. Identification evidence from a lineup or photographic identification. And those are big things, because remember, they're going to say, how do you know it's Nick? How do you know that's his house? Remember, guys, they're showing like they can prove all these things, that he's acknowledging me. The prosecutor has able to prove these elements of the crimes. The evidence of prosecution believes indicates I committed one or more other offenses. And he says, I have the right to a pretrial hearing before a judge determine whether or not the evidence the prosecution has could be used against me if I went to trial in this case. Yeah, it's a suppression hearing. And we know how that went. He says that if I requested such a pretrial hearing, I could testify at the hearing if I wanted to, but my testimony could not be used as substantive evidence against me if I went to trial in this case. And the court just make it clear that Nick understands his rights and how those rights would work and how they would play out. He has the right to contest the evidence that would be presented at trial. And he has the right to challenge their admissibility. And he would have the right to testify at that hearing. And he says that I do not now request such a pretrial hearing, and I specifically do waive my right to have such a pretrial hearing. He's like, I'm not going to bother having it. And he says, whether or not I have had such a hearing, I will not be able to object tomorrow or at any other time to the evidence the prosecutor has. And this is just a way for the court, for Nick to understand, they have all this evidence against you. And you're acknowledging that they do. You don't get to come back later and say, Your Honor, there's still the idea that maybe Aaron did it and Aaron went through and, all of these mealy-mouthed, wrinkly-dicked arguments and hypotheticals Nick has been putting out there. Well, maybe somebody else put it there. Or you don't know what the police put in your house. And when confronted on, he's like, I didn't say that. Actually, I didn't say that. It's taking advantage of, it's taking all those things away. Because we know he's already made these comments. So at this point, Nick is agreeing. Yeah, I'm saying all that's not true. Nope. I'm waiving it all. I mean, I don't know if that's going to be the case for him going forward. We'll see. We'll see. But that is currently what Nick is doing right now. And he says, I have been told. So this one here is going to be very interesting, especially if Nick ends up, having streams in the meantime. He better watch what the fuck he says, because guess who's watching? The prosecution and the prosecutor and the state and the police. They're going to watch it. They're going to go, oh, look who's running his mouth. So, Nick, if you're out there watching this, buddy, I don't know if Frank told you anything, because like I said, I have some concerns about what he's done and hasn't done in your case. You really are going to have to watch your mouth about all the shit you might allege happened. Like all this shit about Aaron planting it, or, all these other things. Like, that's gone, man. That's gone now. That's gone. So, from there, he also says, I've been told by my attorney, and I understand that if I wish to plead not guilty, I'm entitled to a trial by a jury on the issue of guilt, and all jurors would have to agree I was guilty before the jury could find me guilty. And that's true. He would have to be found guilty beyond a reasonable doubt. Now, what happens from here? So they have to prove his guilt beyond a reasonable doubt, and that verdict would have to be unanimous. He also says that if I plead guilty, I will not have a trial by either a jury or by a judge without a jury. And that's true. He won't get a bench trial. You don't have a jury trial. By pleading guilty, you're kind of giving up that right. And he says, that with knowledge of my right to a trial on the issue of guilt, I now waive my right to a trial. And he did. He is waiving it. He says, I've been told my attorney, and I understand that if I wish to plead not guilty and have a trial by jury or a trial by a judge, I would be presumed innocent until my guilt is proven beyond a reasonable doubt. And then he further acknowledges, and this gets to your Fifth Amendment right here, at least Part A. It says, I've been told by my attorney and I understand that if I wish to plead not guilty and have a trial, the prosecutor would be required to have witnesses testify against me in open court in my presence, and then I would have the right to my attorney to question these witnesses. Now, this is, I'm sorry, why did I say Fifth Amendment? I was a little hard. Sixth Amendment. Because he has the right to confront. And he says, that with knowledge of my right to have the prosecution's witness testify in open court in my presence and be questioned by my attorney, I now waive that right. And he says, I've been told by my attorney, and I understand that if I wish to plead not guilty and have a trial, I would be entitled to require any witnesses that I think are favorable to me appear and testify at trial on my behalf. And that's compulsory process, chat. That's the subpoena power. You have the right to do that. I'm talking about the subpoena power, not Nick gazing at Aaron's penis. Different things, chat. I understand why some people might be confused about that. But those are two different powers. The power to subpoenas and the power to see penises, specifically Aaron's. He says, with that knowledge of my right to require favorable witnesses to appear and testify at trial, I now waive that right. All right, so he says, I have been told by my attorney, and I understand that a person who has prior convictions or a prior conviction can be given a longer prison term because of this plea. And that's possible, depending on situations. That could be an issue. He understands the maximum penalty the court can impose for this crime, taking into consideration other prior convictions, is an imprisonment for 25 years. And that a minimum sentence is required by statute. The court may impose a sentence of imprisonment of not less than not applicable for this crime, meaning he is entitled to a sentence of no time. He could be placed on probation right away. And when we talked about up before, chat, the Minnesota sentencing guidelines, he is eligible for parole for this offense, even for the second degree one. And he says that if that for felony driving while impaired or most sex offenses, and he doesn't have to worry about it, it's not here, a mandatory period of conditional release will follow any executed prison sentence that is imposed. Once again, that doesn't matter for Nick. Violating the terms of this conditional release may increase the time I serve in prison. Now, that is something they have to notify you of. You have to know that. If you're sent to prison and then you're released, so conditional release, they might call it parole in other states. In Ohio, it's called post-release control. It sounds like in Minnesota, they call it conditional release. So if you violate the terms of conditional release, you can be sent back to prison. Or if you get new charges while you're on conditional release, they can tack those on and send you back on top of that. He says, in this case, the period of conditional release is not applicable. And he says further that a person who participates in a crime by intentionally aiding, advising, counseling, and conspiring with another person or persons to commit a crime is just as guilty of that crime as the person or persons who are present and participating in the crime what is actually committed. And this happens a lot. This gets around the idea people are going to say, well, I wasn't there, or I just helped, but I didn't help them do it. Or because people, and we've heard Nick do this, you get wishy-washy and you try to weasel your way out of shit. Like, I didn't actually do that. I was just standing around and the other guy was shooting at people. It's like, well, no, you drove the guy to the scene and you know he was going to put in some work. So this is why you're seeing this all in here. This is cutting off things that he may try to raise later and just getting rid of a lot of that. Now, the one thing I will say that I was a little surprised about here when they talk about his trial rights is you don't see this, and this is something I think it should be in here, that he has the right to remain at trial. He has the right to remain silent, and nobody can comment on his silence, and it cannot be used in for guilt. There's also he has the right to testify. I'm surprised there's some things in here that I don't see normally, and I've seen in other guilty plea forms we've covered before. So this one's a little different. It's a little different. So just wanted to comment on that. And he says, I have been told by my attorney and understand. Oh, I'm sorry. He says that my present probation or parole could be revoked because of the guilty plea to this crime. And that's true. If you are subject to any sort of supervision, probation, parole, supervised release, whatever it is, you could face a revocation. Now, it's never guaranteed because this court's generally the court handling your plea is not in charge of that. They're just making sure you understand that could happen. Because if you're not aware of that happening, once again, you're not making a knowing and voluntarily and intelligent plea. Remember, that is the big thing. You have to show that it was knowing, voluntary, and intelligent. If you can't show those three things, then it's not a valid plea. And then he says the prosecutor is seeking an aggravated sentence of, and they're not. So we're not worrying about that. Now, the actual terms here of the agreement. I've been told by my attorney and understand that my attorney discussed this case with one of the prosecuting attorneys, and then my attorney and the prosecuting attorney agreed that if I entered the plea of guilty, the prosecutor will do the following. And this is giving the substance of the agreement. So this is where they start putting it all together, and they start coming up with what's going to happen here. From here, it says he will plead guilty to the amended charge of possession in the third degree. Okay, fair enough. A statutory stay of adjudication pursuant to Minnesota statutes, section 152.18, and we'll go over that in a second. The remaining terms of the sentence at the court's discretion, meaning whatever else the terms of the sentence, including probation, would be at the court's discretion. The state drops all other charges. That's not unheard of. And then the state's dismissing the case against Kayla and the case against April, which I am actually surprised. Like, the one against April, I get it. That's a little tougher. But the one against Kayla, I'm actually a little surprised about because I'm not going to lie, where I've been prosecuted before, we wouldn't just drop it like that. It was in the house. She knew it was in the house, and like she was doing the drugs too. Does that mean that Nick went ahead and made a proffer and ran a gossip column to the police about like everything he knew, where all the drugs went, how he was getting them, and all the information he could provide, and was willing to cooperate? Maybe he traded all that in exchange for their freedom. But just the idea of him just saying, like, I know Nick might tell the story as like, I walked in there and I told that woman, you're going to drop the charges against my hoe. And the prosecutor went, Mr. Rekieta, of course I'll do it. Don't yell at me. I'm so scared. I'm sure that's how he's going to portray it. That's not how it went. I'm sure he said, what do I got to do to help them out? Do you need me to offer? Do you need me to snitch? Let me do whatever it is I got to do. And he sat down with the cops. He told them everything he knew, probably showed them everything on the phones. Where did I go? Where did I buy? How much? And do all that. And I'm sure they use that to do investigations furthering those. So that is, I'm just saying that's likely how that happened. The idea they're just like, oh yeah, have fun. We'll take it easy on everybody else, and you're just gonna eat it. I just don't see that happening. Just don't see that happening like that. So we're gonna keep going here. And it says that if the court doesn't approve this agreement, and this is written in here in pen, that doesn't change the issue in this case. I've had plea agreements before where we add in something at the last minute or we change something, and instead of running down the hallway, the prosecutor go print out a new copy or something. It's just easier to write it in, and then we just sign, we sign it like normal. And then we just, on the record, the judge is reading through it, and he says, I noticed this is, judge says, I noticed there's a handwritten count here, and condition is blah, 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 blah. And we say, yes, Your Honor, we agree to that. Prosecutor says, yep, I agree. That's a correct recitation of facts. So that's not a big deal. That's not a big deal. And then it says, If the court doesn't approve this agreement, I have an absolute right to then withdraw my plea of guilty and have a trial. He says, any testimony I have given concerning the guilty plea cannot be used against me unless I'm charged with the crime of perjury based on the testimony. And then he says, 21, he's like saying that except for the agreement between my attorney and the prosecutor, no one, including my attorney, any police officer, prosecutor, judge, or any other person has made any promises to me, to any member of my family, to any of my friends or other persons in order to obtain a plea of guilty from me. And that's always asked, have you been coerced? Are you doing this under duress? Have any promises been made outside of this agreement to induce your plea? And that no one, including my attorney, any officer, prosecutor, judge, or any person, has threatened me or any member of my family or friends in order to obtain this guilty plea. He goes on to number 22. My attorney told me I understand that if I plea, that my plea of guilty is for any reason not accepted by the court, or if I withdraw the plea with the court's approval, which you always have the right to withdraw your plea through leave of court, but you do have the ability to do it prior to sentencing. After sentencing, you can, but it's really, really hard. Before it, it should be liberally granted withdrawing your plea before sentencing. And that could be right up to the minute of sentencing. I did an appeal probably about 3-4 months ago. Actually, yeah, it's about 3-4 months ago. The guy ended up wanting to change his plea right before sentencing. He came into court and he's like, Your Honor, I want to withdraw my plea. And the judge said, you ain't doing that. And the court of appeals like, the you ain't. He gets to withdraw his plea. And yeah, the guy ended up pushing it to trial and they ended up cutting him a smoking deal. Then he says, or if this plea is withdrawn by court order on appeal or other review. He says, and that's the thing. The court of appeals could say, this is a bad plea. You can't do it. Something is structurally defective in it. We have to, this doesn't count. That he would stand trial on the original charge and charges. And that's true. The prosecution could proceed against me as if there had been no plea of guilty and no plea agreement. And that's true. The prosecutor never has to offer you a plea agreement. They can just say the plea agreement could be plea to the charges. And I've had cases like that before as a prosecutor where I did that. The guy had it, the attorney comes in, hey man, what's your plea offer? Plea to the indictment. Now, in this situation, there's a lot of times where it's like, okay, yeah, here's the plea deal. But you don't have to offer one. You don't have to offer a deal that's good. And then he says, from there, he says, my attorney has told me, and I understand that my plea guilty is accepted by the judge. I have the right to appeal. You always have the right to appeal. You have the right to appeal as a matter of right. Meaning you have the ability to automatically appeal. And it's not a discretionary appeal. But then any appeal or other court action I might take claiming error in the proceedings probably would be useless and a waste of my time in the courts. Now, that's just an acknowledgement, and typically it is, chat. When people appeal sentencings or plea hearings, there are, through the rules of criminal procedure and decades of case law, what are acceptable ways to do a plea hearing and to do a sentencing. And the judges go through judicial college, and they have conferences, and if some judge f***s up and the Court of Appeals or the Supreme Court says that's not acceptable anymore, they learn that, and then they get notes. And, if you ever notice a judge, if you're ever in a situation where you see a judge is brand new, even if they've been an attorney for a while, they're going to you're going to see that they're going to be reading off kind of like a checklist, basically like a script. Now, as they've been a judge for a while, a judge who's been doing it for years and years on end, they do a lot of pleas. They can do enough of them where they're just sitting there and kind of like I'm talking to you guys. You can talk about, like, hi, what's your name? How old are you? What's your level of education? Do you understand the English language? Do you understand your trial rights? Do you understand what happens here? You go boom, 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 done. So you can tell there's a difference in that. But there might be a time when the court f***s up. The court f***s up the plea hearing. Sometimes that happens. Very rarely, but it does. And then my attorney that has told me, and I understand, that a judge will not accept a plea of guilty for anyone who claims to be innocent. Yeah, so this right here, this is another way of saying this ain't Aaron's Coke. And I now make no claim that I am innocent. It's not Aaron's Coke. It's Nick's Coke. Nope, it's mine. This is a complete and full admission of guilt to possessing cocaine in the 3rd degree. It's a complete and full admission to that. There is no actionalese or asterisk on it. Nope, it's mine. It's mine. So it'll be interesting to see if Nick, once again, can keep his mouth shut going forward. Because as when comments come in, Nick's like, well, you could have been a steel toe man. Or, as he said again with Chrissy, how do you know the police didn't plan? I never said that. It's like, no, he's going to have to own to it. Yeah, it's mine. Yep. Mm-hmm. You know, if like I'm just saying, you start making those lunatic arguments again, the state's going to learn about that, and they'll be like, well, he's not being serious about this. So that's free advice. It's free advice for anybody out there who needs it. I've been told by my attorney, and I understand that if I wished to plead not guilty and have a jury trial, if I could testify I want to, can I force testify? And then said nobody could comment on, I forgot this down here at the bottom, that neither the prosecutor nor the judge could comment on my failure to testify. I don't know why they don't put all the trial rights together. There are things on here that we don't see, though. That, like, if he's placed on probation, how long could probation be? You know, like how those things would work and how long would conditional release be? And how are those things calculated? In Ohio, you also get the right to be advised of, like, you're able to earn good time credit. How much good time credit can you earn? And through other programs, how much more time can you earn off? So that's why, like I said, this one's a little different. There's just a lot of stuff here that I don't, yeah. Then he says, my attorneys told me, and I understand that if I'm not a citizen of the United States, that with knowledge of my right not to testify, and that neither the judge nor the prosecutor could comment on my failure to testify at trial, I now waive and give up this right, and I will tell the judge the facts of the crime. Now, guys, remember how I told you, as part of a plea, you have to do the allocution. And the judge is going to say, Mr. Rekieta, is it true that on or about May 23rd, 2024, you did, in fact, possess cocaine, and you did possess drugs as a felony of third degree, and particularly 2-wick cocaine. And did that happen? And Nick's going to say yes. And the judge might say, tell me what happened. Now, normally, like I said, you don't have to give a massive speech. It doesn't have to sound like something out of Tolkien. But you have to say, yeah, I had drugs in my house and I had cocaine in my house and the police found it. And you've got to say something like that. So if the allocution, that'll be in there, and that'll be on, the court's going to ask. Now, the court may ask, some judges ask more questions, like, well, what was going on? Tell me about it a little bit. Some don't. Some say, that's good enough. And then he says, my attorney has told me, and I understand that if I'm not a citizen of the United States, this plea of guilty may result in deportation, exclusion from admission to the U.S., or denial of citizenship. So if you are just here and you commit a felony, you got to go back. Got to go back. And that is something you have the right to know, because if you don't know that, you can claim, I didn't make the plea knowingly, because I didn't know this is going to happen. And that immigration concerns are a very serious risk. So that is something that I think pretty much everybody has, this idea. And usually it's right at the end like this. And it says, in view of all the above facts, I wish I would plead guilty, dated January 24th, squiggle, 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 signed by Nick Robert Rekieta. So that is the plea form. And that's it. That is it in this situation here.